All right, we are on the record then in file 22-20750-FH, People versus Mason Bradley Lindeman. We are here today for a final pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
James Daly on behalf of the defense attorney.
All right, we have someone from the prosecutor's office handling Mr. Lindeman today.
Is Ms. Mayor in your waiting room?
Oh, I'm sorry. No, she is not.
Okay, Jackie Wise on behalf of the people.
It is final pretrial. Do you want me to wait for Ms. McClure?
If you wouldn't mind.
Okay. All right, so we'll pass this until Ms. McClure gets logged in. Ms. Chartier, do you need a breakout session with Mr. Warner?
No, Your Honor, we've already chatted.
All right. Okay, we are on the record then in file 24-21841-FC, People versus Dale Warner. We are here today for a pretrial conference in this case, and we are proceeding today by partially in person and partially by video conference. First, can I ask the attorneys to place their appearance on the record, beginning with Ms. Wise?
Good morning, Your Honor. Jackie Wise on behalf of the people.
Good morning, Your Honor. Mary Chartier on behalf of Dale Warner. We are both participating via Zoom. Thank you.
All right, and so I know that the transcript of the preliminary examination was just filed yesterday. Where do we stand with the case other than that?
So I'm happy to chime in. We just got the transcript. It is a number of pages, as the court likely knows. The prosecutor and I are meeting next Tuesday, September 10th. We know that there's some discovery that we don't have, not for any, I think, nefarious purpose, just because a lot of things have been going back and forth. Also, we know we're missing some discovery from the most recent events. We did receive some yesterday. So I think that's a really good starting point for us to know essentially how much time we'll need to review whatever may still be outstanding. Also, I fully expect a pretty vigorous motion practice that will likely occur once we have all the discovery and have reviewed the transcripts as well. Also, there is a pending protective order that Ms. Wise and I are in the process of working on related to some items from the Ambassador Bridge. So once that's prepared, I believe Ms. Wise will, I think it's been prepared and we're working on revisions. Once that's reached, then she'll submit that to the court and then we can receive those materials. So I think that we're moving along as best we can at this stage. But again, we do know that there are some outstanding matters.
Ms. Wise, anything to add from the people?
No, Your Honor. I would just ask for another pretrial, probably 60 days out. That would give us time to maybe Ms. Chartier will have some idea of what types of motions and maybe have them filed by that time, and we can move forward with a little bit more understanding at that point.
All right, Ms. Chartier, are you in agreement with that?
I am, Your Honor. Thank you.
60 days would take us to the beginning of November. We can do November 6th at 8:15.
Unfortunately, I'm in a trial November 6th as well as on November 13th. I don't know if the court is amenable to going to October 30th. We're supposed to start a trial that week as well, but that one is a little in flux. So I could certainly let the court know if October 30th doesn't work, but I certainly hope it does.
Ms. Wise, would October 30th work for people?
Yes, Your Honor.
All right, so we'll set it for October 30th at 8:15 a.m. for another pretrial.
If that date does not work, if the trial does go, would the court like me to prepare a stipulation, work with Ms. Wise, and then work with your chambers on a new date?
That would be fine. Just contact us as far in advance as you might know, so that we can have some advance notice.
Thank you. And would the court like a stipulation today on the new pretrial date?
Yes, if you could prepare that, I would appreciate it.
I will, Your Honor. Thank you.
Is there anything else we need to address with this case today?
No, Your Honor.
No, thank you, Your Honor.
All right. Thank you for your time then, Mr. Warner. You can let the officer with you know that you are done with court for today.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Okay, let's see, Ms. McClure, are you there? Mr. Fifelski, are you ready to proceed with Mr. Cook?
Yes, we are, Your Honor, and we have reached a plea resolution.
All right, is that going to require an amended information, do you know?
I believe it will, and it will be a no contest plea. So I think we were going to have the police reports in the courtroom.
Yeah, I can bring I can bring those up, and I'm going to need just a second to get the plea form completed.
Okay.
So yes, Mr. McCready, we're ready to proceed as we last discussed.
Sounds good.
Thank you.
Okay, Mr. Daly, we've got Ms. McClure here now, so we can proceed with Mr. Lindeman.
Ready there?
So back on the record in file 22-20750-FH, People versus Mason Bradley Lindeman, here today for a final pretrial conference in this case. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure for the People.
On behalf of the People.
James Daly on behalf of the defendant.
Right, and Mr. Daly, where do we stand with Mr. Lindeman's case today? Are we ready to proceed to trial?
There has been a plea bargain offered in this case. I've been over to the jail. I talked to my client about that. I indicated to him the ramifications of that. And right now, as it stands, the plea bargain could result and would result, I believe, in a significant prison sentence. He's not interested in taking the plea bargain at this time, and we'd have to have him set for trial.
Your
Right,
Honor,
so we have trial. I'm sorry.
I was gonna say, as far as trial goes, we submitted our voir dire, jury instructions and verdict form. I'm trying to think what else. I think the only thing, and we've submitted our amended or our final witness list, I should say. I think the only thing yet to do is to exchange exhibit lists, but otherwise the people are ready to proceed to trial on the 10th.
All right, Mr. Daly, is the defense otherwise ready to proceed to trial?
Yes, Your Honor.
All right, we will proceed then, trial set for September 10th at 9 a.m.
Thank you, Your Honor.
Thank you.
All right, thank you, Mr. Lindeman. You can let the officer with you know that you are done with court for today. All right, the other gentleman at the jail, you are Mr. Jacobs, correct?
Yes, sir.
And
We're looking for his attorney right now. We can't find him.
All right, so your attorney was here, but he's wandered off, so we'll proceed with your case, Mr. Jacobs, as soon as he comes back.
Okay, thank you, Your Honor.
All right, for the person that just logged in with the device name Motorola Moto G Stylus 5G 2004, can you tell me your name, please?
Cody Felton.
Okay, 1 second. All right, Mr. Felton, I don't believe your attorney is logged in at the moment, so I'm going to put you back in the waiting room, and as soon as Mr. Dagger-Margosian is here, I will bring you back in.
Yes, yes.
Who was it?
Nimer, Mr. Nimer.
Okay. Mr. Glazer, Mr. Nimer is here in the courtroom. Do you need to speak to him?
No, Your Honor.
All right, Mr. Nimer, do you want to come forward to the podium, please?
Your Honor, did you say the podium?
Yeah. Okay, these are files 24-21792-FH, 24-21872-FH, and 24-21873-FH, People versus Bailey Assad Nimer. We are here today for a pretrial conference in these cases, and we are proceeding today by video conference. First, going to have the attorneys place their appearances on the record. Who do we have from the prosecutor's office handling Mr. Nimer?
I can cover it, Your Honor.
It's Mr. Glazer.
Okay, go ahead, Mr. Bayonetto.
Alex Bayonetto for the people.
John Glazier on behalf of Mr. Nimer.
Okay, and Mr. Glazer, where do we stand with Mr. Nimer's case this morning?
Your Honor, we'd asked to have a pretrial adjourned, possibly 60 to 90 days. I got to get with Mr. Nimer, and I think we'll probably get this case worked out from, they've made an offer, and I need to review it with Mr. Nimer and go over some other stuff.
Mr. Bayonetto, is there anything that we need to address from the people's side?
No, Your Honor.
I'm sorry, did you say 60 days, Mr. Glazer?
Yeah, at least 60, Your Honor.
So the oldest case is bound over in April, so I can do 60 days, but at that point, I'd be looking to set it for trial if the matter hasn't resolved at that point, if there's no,
That's fine, Your Honor.
So 60 days, we'd be looking at, we can do November 6th at 8:15.
That would be fine, Your Honor.
All right, so Mr. Nimer, your next court date will be November 6th at 8:15. You can come in person as you did today, or you can log in by Zoom for that one.
Oh, okay. Thank you.
The bailiff can give you our Zoom
Mr.
information.
Nimer, set up an appointment to come and see me.
Sounds good. I do have court the 26th as well. Will that be a separate?
That's down in district court, I think.
Okay, I apologize.
All right, so November 6th, Mr. Glazier, will you do the stipulation and orders for those adjournments?
Sure, Your Honor. Thank you.
All right, thank you. And Mr. Daly, I have Mr. Edwards in a Zoom room at the jail. Do you need to speak to him?
No, Your Honor. But Your Honor, in regards to Mr. Edwards, I would indicate to the court that he has several charges. He posted bond.
Oh, okay. Can you let me call the case first, Mr. Daly?
Oh, I'm sorry.
All right, these are files 24-21781-FH, 24-21782-FH, 24-21783-FH, 24-21784-FH, and 24-21785-FH, People versus Nathan Wayne Edwards. We're here today for pretrial conferences. In all of those cases, we are proceeding today by video conference. First, let me ask the attorneys place their appearance on the record, beginning with Mr. McCready.
Dave McCready for the people.
James Daly on behalf of the Your Honor.
All right, and Mr. Daly, where are we with Mr. Edwards' cases today?
Your Honor, Mr. McCready and I were ready to try this case. We may still be trying the case. The problem is that there is new charges in district court, felony charges arising out of his absconding on bond. And based upon that, I need to talk to him again, but I need to get all of the charges put together so that we can have a global settlement if we're going to have that. And we don't have all of the cases up here yet.
Okay, what's the status of new charges? How close are we to getting it up here if it's going to come up here?
That's whenever the prosecutor has it ready, I'll be ready. But I would tell the court that I believe that there's going to be a trial. Mr. McCready and I have tried to resolve it. Mr. McCready has made a fair offer. I've communicated that offer to my client. My client's rejected it, and I don't know that that's going to change. And that doesn't include the new trials yet, or the new cases yet.
All right. Well, I mean, at this point, I'm sorry. Go ahead, Mr. McCready.
Well, then we have excuse me, we have a pretrial conference on the 17th in district court. I believe that's the next court date on the new case.
I'm sorry, did you say the 17th?
Yes.
Okay, well, I guess I'd be inclined to set it for trial based on what I've heard and based on the fact that we had it set for trial once already. We know what the new charges are, I would presume. So if there needs to be discussion about the possibility of a resolution, I think you can do that between now and the time that we would set it for trial. And if I recall correctly, you would agree to set, you agreed on which file to try first, and it was not the lowest number. Is that correct?
That's correct. I think the file we agreed on is 2421785.
Is that accurate, Mr. Daly?
Yes, Your Honor.
And I think we had it set for 2 days. Is that still sufficient?
I believe
Yes,
so.
Your
Okay, Ms. Clark, can you find us a 2-day jury trial date for Mr. Edwards?
Tuesday, December 3rd at 9 a.m. and Wednesday, December 4th at 10:30.
That's fine, Your Honor.
You can. You got a doctor's appointment. That day doesn't work for me. out of town that day, Your Honor.
Okay, Ms. Clerk, you find us at a different date.
December 5th at 9 a.m. and December 6th at 9 a.m.
Those work fine.
That's fine for the people.
Okay, so we'll set it for December 5th and 6th at 9 a.m. And let's do a final pretrial on November 27th, if that works.
Your Honor.
That's fine.
Okay, the court will issue a scheduling order. I'll set pretrials on all the other files for the same November 27 date. If you do get something resolved before that, you're welcome to contact the court and set up a pretrial earlier than that to get it taken care of.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Mr. Edwards, you can let the officer that's with you know that you're done with court for today.
Okay, thank you, Your Honor.
Could we have Matthew Fonseca, please? All right, thank you. Bye.
Mr. Daly, I still had Mr. Levi for you. Is he happen to be in your office? You're muted, Mr. Daly.
He's supposed to zoom in from his house, Your Honor. But we haven't heard from him. We haven't reached him. I think he's going to take the plea bargain.
All right, I'll give him a few more minutes to see if he logs in, I guess. Call jail and have them replace Jacobs with Teresa.
Little Kelly Judge with Siggers. We currently have Andrew Jacobs in the room, but we're waiting for his attorney. Can we have him removed and replaced with Teresa? Thank you.
Okay, Mr. Jacobs, I need to use that Zoom room for other people, so we're gonna have someone else brought to that room, and we'll bring you back when your attorney comes back.
All right, Your Honor.
Sorry,
Oh, no problem. I just want to make sure you're here.
I can.
Your Honor,
Yeah,
Levi is unavailable today. We've tried to reach him. They said his device is unavailable to reach him. We can't reach him. And he knows he's supposed to be here. And he knows there was a plea bargain in place.
this is file 24-21875-FH People versus Eric Brian Levi. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me ask the attorneys place their appearance on the record. Do we have somebody from the prosecutor's office?
Maybe McClure, be the people.
James Daly for the defendant.
All right, this matter was set for pretrial conference at 8:15 this morning. It's now 8:56. Mr. Levi is not present in the courtroom and has not logged into the Zoom session this morning. Mr. Daly, is there anything you want to say with respect to Mr. Levi at the moment?
He knows that he was supposed to be here. There was a plea bargain on the table that would have resulted in no further incarceration. I know that's off the table now. I have nothing else to add.
All right, this appears to be first failure to appear by Mr. Levi, so I'm going to wait for 48 hours. If the court's not heard from Mr. Levi within the 48-hour period, at that time, I will revoke and forfeit his bond and set or issue a bench warrant for his arrest. I would set bond on that bench warrant in the amount of $10,000 cash or surety. But if he does get in touch with the court, or if he gets in touch with you, Mr. Daly, do you want to get in touch with the court? We'll reset this for another pretrial date.
I understand.
Okay, that will be all on that one. Then. Thank you.
Thank you.
Can I approach?
Yeah.
These are the police reports for unedited plea at Cook.
Okay. Did we need an amended information?
That's being worked on right now, so it's almost
So
done. And I'll
email it up?
I'll email it up.
Okay, great, thank you.
So she's.
Okay, Mr. Fry, we have Teresa Ward in a Zoom room at the jail. Do you need a breakout session with her? I'm sorry, I guess Mr. Fry logged out. Who's the person? All right, the gentleman at the jail in the yellow, can you tell me your name?
Matthew Fonseca.
Okay, Mr. Glazier, do you need a breakout session with Mr. Fonseca? Mr. Glazier, are you there?
Sorry, I need to speak with the prosecutor that's handling this.
All right, who's the prosecutor handling Mr. Fonseca's case?
Looks like Miss Wagner. Maybe he can give her a call.
I tell you what, Judge, this is just an arraignment. Why don't we do the arraignment and set it for pretrial?
Okay. These are files 24-21936-FH, 24-21937-FH, and 24-21919-FH. Oh, I'm sorry.
Why don't you just get a new lawyer? Why don't you just get a new lawyer? It's been 3 months.
All right.
You don't know how to talk to
All
nobody.
right.
How about I get a new lawyer? How about I
Mr.
need a new
Fonseca,
lawyer?
stop being
That's what I
disruptive.
need.
Stop
Glazer don't
being
know how to talk to
disruptive.
nobody. My life's on the line. I need a new lawyer.
Mr. Fonseca, stop being disruptive. You're prohibiting these court proceedings from going on in an efficient manner, and if you continue to do that, I'm going to hold you in contempt.
Your Honor, let me talk to Mr. Fonseca.
I don't want to talk.
You don't want to
I want
talk?
a new lawyer. No, I want you fired. New lawyer, represent myself.
Mr.
I know more
Fonseca.
than you.
That's fine.
Okay, thank you. Let me go back to my cell. Are we done? Are we
No,
done?
we are not done. Stay where you
Okay,
are.
then. Make
Sit
sure
down.
my life's on the line.
Again, these are files 24-21936-FH and 24-21937-FH. People versus Matthew Lewis Fonseca. We are here today for arraignments in both of these cases. Mr. Fonseca has just raised the issue of wanting to fire his lawyer. Mr. Fonseca, you are represented by the Public Defender's Office. I do not control who from the Public Defender's Office represents you. They have a process within the Public Defender's Office for assigning a new lawyer if you are dissatisfied with the lawyer that's been assigned to you, and you will need to follow that.
I'll present myself.
You want to represent yourself? So Mr. Fonseca has left the Zoom pod after indicating that he wants to represent himself. So at this point, I don't believe I can proceed with the hearing. Because I've not been able to comply with the procedural requirements for the arraignment. What I'm going to do is adjourn the arraignment on Mr. Fonseca's cases to tomorrow morning at 8 a.m.
Your Honor,
Yes.
could I ask that Mr. Fonseca be brought over so I could talk to him in person tomorrow?
Yes, we will request to have him in person. So tomorrow morning, 8 a.m.
Oh, 8 a.m. Okay, I thought you said 9. 8 o'clock?
Yes.
All right.
Okay, sir, you're here for Mr. Jacobs?
I am, Judge.
All right, give him a call from Mr. Jacobs.
Let's call the judge and say, could we move Andrew Jacobs and confirm for the judge, please? Thank you. Bye.
Just, you know what the spot pool is? I couldn't figure it out with the register of actions. Looked to me like everything had been posted.
So he has, it looks like, 5 contempts of court in addition to the charges. On the charges, he's got a $28,000 cash or surety bond. The 5 contempts of court, he posted the first 3. The 4th was a PR, a $60,000 PR bond, and then the 5th was an $80,000 cash or surety bond. So it looks like that's the only one that has not been posted.
Thank you.
I think we're ready for Mr. Jacobs. This is file 24-21919-FH, People versus Andrew Frederick Jacobs. We are here today for an arraignment in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. McCready.
Dave McCready.
Good morning, Your Honor. Spencer Clayton appearing on behalf of Mr. Jacobs, who appears via Zoom through the jail, P number 77302.
All right, and does Mr. Jacobs wish to have the information read?
No, Your Honor, we waive the formal reading of the information. He'll stand mute and ask the court enter not guilty on his behalf.
All right, so we'll enter a not guilty plea for Mr. Jacobs. We'll set this for pretrial conference. How about October 16th?
That works.
So October 16th at 8:15 a.m. You're welcome to do that either by Zoom or by in person.
Thank you. Your Honor, may I address
Yeah, go ahead.
As we spoke off the record, he does currently, he's posted numerous bonds except for the last, the fifth contempt of court, which is currently at 80,000. I'd asked the court to consider lowering that bond. I know that he tested the last time we were here for his exam. It was a negative test. The court at that time had indicated that there may have been a faint amount, but it was a negative test. There was a prior test before that as well. He's adamant he hasn't been using narcotics. He has provided the court a valid medical marijuana card, and I know that he is testing positive for that, but again, that's prescribed through the Medical Marijuana Act. I'd ask the court to consider lowering his bond or setting for a bond hearing. So, and if we need to put in a formal motion for that, we can. So,
at this point, I'm going to require a more developed hearing and a motion. Just looking through the file, you know, there's 5 contempts of court. They're all related to either testing positive or failing to test. The most recent of which was a positive test on August 12th for 2024. Because the allegation is that he tested positive for fentanyl. And so I'm not comfortable making any changes to his file.
Your Honor,
Just based on the file.
so we can put in just a second, Mr. Jacobs. So we'll put in a formal motion request, and we can have a hearing then. Would that be before the October 16th date, or we just put it in and just procedure wise?
If you want to call and talk to my judicial assistant, Francis Clark is her name.
Okay.
You can, if we have a date available to give you before the next pretrial, I'm happy to do that. Just don't schedule it. Probably the easiest way is just give her a call.
Okay. Thank you. Mr. Jacobs, I'd advise you not to say anything regarding the case, obviously.
okay.
All right, so
I'll come
Mr.
see you, Joe.
So Mr. Jacobs, you're all set for today. You can let the officer know that you're done with work.
I have no idea what happened here, Your Honor.
So
Yeah.
we entered a not guilty plea for you. Today was a day for you to plead. And we entered a not guilty plea. We set a pretrial conference, and your attorney is going to schedule a hearing about your bond situation.
Okay. All right, thank you, Your Honor.
Okay, thank you. Okay, Mr. Fry, do you need a breakout session with Ms. Ward? I didn't hear what you said.
Oh, sorry. No, Your Honor.
Okay. These are files 24-21922-FH, 24-21923-FH, and 24-21924-FH. People versus Teresa Lynn Ward. We are here today for arraignments in all 3 of those cases. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. McCready.
Dave McCready for the people.
Brian Fry, attorney for Teresa Ward.
All right, and Ms. Ward is present by Zoom from the Lenawee County Jail. Mr. Fry, does Ms. Ward wish to have the informations read?
No, Your Honor, we would waive the reading of the information in each file. I advise my client also of her rights. So we have reached a plea agreement in this case, which has been submitted to the court, and we would be asking to proceed with that.
All right, you want to state the terms of the plea agreement?
Yes, Your Honor. My client would plead guilty to the count 4 and 5 of the amended information in file 2421923FH, which is a possession of heroin and a possession of cocaine. Counts 1 through 3 in that file would be dismissed. In file 2421922, the counts would be dismissed. In file 2421924, the counts would be dismissed. And then in misdemeanor file 220118OT, that case would be dismissed. And then and that's the agreement, Your Honor.
Okay, Mr. McCready, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
All right, Ms. Ward, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Teresa Lynn Ward?
Yes, I am.
Ms. Ward, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 4 in file 24-21923-FH, possession of heroin?
Yes.
Is it also your intention to plead guilty today to count 5 in that same file, which is possession of cocaine?
Yes, it is.
Do you understand that the maximum possible penalty for the possession of heroin charge is up to 4 years in prison?
Yes, I am.
And you understand that the maximum possible penalty for the possession of cocaine charge is also up to 4 years in prison?
Yes, I am.
Are you satisfied with Mr. Fry and the advice he's giving you?
Yes, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the courts. Is that correct, Mr. McCready?
It is.
Mr. Fry?
Yes, Your Honor.
Is that also your understanding, Ms. Ward?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Ward, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, I am.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, I am.
If you're not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, I do not.
Do you understand that you're giving those rights up?
Yes, I do.
How do you wish to plead to the charge that on or about August 12, 2020, in the city of Adrian, county of Lenawee, that you did commit the offense of possession of heroin?
Guilty.
And how do you wish to plead to the charge that on or about August 12, 2020 in the city of Adrian, county of Lenawee, that you did commit the offense of possession of cocaine?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, they have not.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that your pleas were given as a result of threats or promises disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, I do.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Ward to plead guilty?
No, Your Honor.
No, Your Honor.
Ms. Ward, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, it is.
All right, Mr. Fry, do you want to cover the factual basis?
How you doing today, Teresa?
Hi.
So do you recall the date of August 12th, 2020?
Yep.
Okay. And at that time, were you in the city of Adrian, county of Lenawee, state of Michigan?
Yes, I was.
Do you remember the address where you were at?
629 East Longmead Street, apartment 3,
Okay.
Adrian, Michigan.
Okay. And did you have a room in that apartment?
Yes, I did.
Okay. And on that occasion, did you have heroin?
Yes.
Okay. And did you know it was heroin?
Yes, I knew there was heroin at the address. Yes.
Okay. And was the amount of heroin that you had less than 25 grams?
I bet I couldn't tell you.
Okay. Do you think it was probably less than 25 grams?
Yeah, sure. Yeah.
Okay.
Yeah.
And did, on that occasion, did you also have cocaine?
Yes.
Okay. And did you know that substance that you have was cocaine?
Yes.
Okay. And was the cocaine that you had, was that less than 25 grams as well?
Not aware of what the weight size was of it, but I do know that it was there. Yes.
Okay. Do you think it was probably less than 25 grams?
Sure. Yeah.
Okay.
Okay.
Where did you get those drugs?
From the Sean Perkins.
Okay.
Oh,
Okay. I have nothing further.
People are satisfied.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Fry?
Yes, Your Honor.
I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Ms. Ward has had full knowledge of her rights and she has had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. And we will set sentencing for October 11th at 8:15 a.m. Ms. Ward, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
yes, sir.
Okay. So you can let the officer know that you are done with court for today.
Your Honor, can we address bond?
Yes, go ahead.
Your Honor, so my client is not at risk to herself or anybody in the community. She's cooperative in this case. My understanding is the prosecutor is agreeing to a PR bond at this time. My client lives locally, so we do believe that the PR bond would be appropriate, and we're asking the court to enter that today. Thank you.
That's correct, John. We have no objection. We have no objection to a PR bond at this point.
All right, then, based on that agreement, I will issue a personal recognizance bond for Ms. Ward.
Thank you, Your Honor.
Hey, Teresa, as part of your bond conditions, you are to test 2 times a week. So once you are released from jail, do immediately come over to see me.
Yeah.
I'm located up on the 3rd floor. So once you come out of the elevators, go over to the clerk's office and ask to see me.
Okay, dear.
And then Judge, when she's released, she needs to report to probation as well.
On the third floor also?
Also on the third floor, yes.
Yeah, okay.
Okay, so you are all set for today. Thank you.
Thank you, Your Honor.
You got that. Sir McCready, we're still waiting on that information for Mr. Cook.
Yep, just putting the finishing touches on it.
Okay. Thank goodness. Okay. Okay, Ms. Hennigan, are you ready to proceed with Ms. Flores?
Yes, Your Honor.
This is file 24-21886-FH People versus Emily Christian Flores. We are here today for a pretrial conference in this case, and we're proceeding today by partially by video conference and partially in person. Sorry, I don't see Mr. Bayonetto here. He had.
I can text him. He may have popped over to Judge Gonzalez.
Unless you need Mr. Banetto, I can fill in. Just my video is not working this morning.
Oh, all right. Go ahead then and place your appearance on the record, Ms. McCourt.
BB McClure on behalf of the people.
Samaris Hennigan on behalf of Emily Flores.
All right, and it's my understanding that you have gotten a trial date. Is that accurate?
That is accurate, Your Honor. For the record, I would indicate that my client was present here and timely this morning. She has been notified of the dates. There was a plea offer, the plea offers to plead as charged. So my client at this time is choosing to go to trial.
Okay, and what was the trial date that you got?
November 8th for trial and October 30th at 8:15 for final pretrial.
All right, is there anything else we need to address with this case today?
No, thank you, Your Honor.
Okay, thank you for your time. Court will issue a scheduling order.
Thank you.
Mr. Daly, did you have someone else today that I missed? You are muted.
Lindeman, Your Honor.
Mason Lindeman?
Yes, or do we already do that? But if we
we did that one.
Okay, then I'm all set.
Yep, okay, we're set for trial on that one next week.
Right. Thank you, Judge.
Thank you. Okay, and then we had a different Mr. Lindeman here, and your attorney is Ms. Underwood, so we're waiting for her to either get logged in or come into court. And so you're Mr. Sinclair. So we're waiting on Mr. Malaro. As soon as he gets here, we'll move forward with your case.
Thank you, Your Honor.
Well, it's Kelvin Judge Olsaver. Can we have Kenny on so too, please? Thank you. Bye.
Okay, Mr. Dagger Margosian, do you need to speak to Cody Felton?
I'd like to have a word with him, please, Your Honor.
All right, Mr. Felton, I'm going to put you in a breakout session with Mr. Dagger Margosian. Mr. Felton, do you have a request to join a breakout session? Can you hear me, Mr. Felton?
No, sir. Yes, I can hear you.
Okay, give me 1 second. We'll try it again. Okay, sorry, Mr. Dagger Margosian, we're having a little issue with the breakout session, so let me try it once more. Okay, Mr. Felton, do you see a request to join a breakout session now?
Nope, still don't see one.
How about now?
No, sir.
All right, Mr. Dagger Margosian, I don't know what the problem is, but we don't seem to be able to get Mr. Felton into a breakout session. Do you want to try just calling him separately?
Well, that's fine, Your Honor. I guess what I'll say is we're ready to accept the plea. I believe that the court has now received a plea form as well as an amended information, and we're ready to move forward unless Mr. Felton needs to have a private conversation with me. But if everything is the same as last time, we're ready to move forward here.
All right, I do have the amended information. I don't think that a copy of the plea form has made its way to me. Is that something that can be emailed? Is the plea form something that can be emailed?
You talking to me, Judge?
Yeah, yeah.
It could be. I'd imagine it would come from the prosecutor's office. I mean, this is Mr. Sneed's case. I don't know which APA is covering.
All right, do we have someone covering the Cody Felton case today?
All right. Judge, I can hop on. Once again, I don't know if there's a signed copy of a plea agreement in our file. If it's been signed by both parties, I'm happy to forward it to the court. Give me just a second to find that. Mr. Margosian, has that been signed?
No, it hasn't been signed. We could put it on record. I can sign it and send it to the court later, but I'm happy to put the confirmation on record.
Okay. See if it's in the file. But I can email the plea form to Mr. Dagger Margosian, and once he signs that, we can put it on the record.
I have the plea form. I'm at home. I don't have a printing unit. I'm going to the office later this afternoon. Again, I can.
Okay, can you give me permission to sign it for you and your client, and then we'll email it to the court?
Yes.
Okay. Judge, if we can call another case, I will sign this and have it scanned and email it to the court.
All right, while we're doing that, Mr. Dagger Margosian and Mr. Glazier, I do have Mr. Silvertooth in a booth at the jail. Do you need a breakout session with him?
Your Honor, I'll defer that to Mr. Glazier.
Yeah, we should have a quick brief breakout, Your Honor.
All right, give me 1 second. Mr. McCready, still waiting on that amended information for Mr. Cook.
Let me check with my secretary, see what's done. I'll be right back with you.
Thank you. Okay, Mr. Murphy, do you need to speak to Mr. Blevins?
Just briefly, Your Honor.
All right, 1 moment.
Thank you.
This is file, sorry, hang on.
And Judge, I am here. Just again, my audio or my video is not working.
All right, so this is file 23-21612-FC, People versus Kenyatta Wayne Silvertooth. We are here today for a final pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Arnold for the people.
Allison Arnold for the people.
BB McClure also on behalf of the people.
John Glazier on behalf of Mr. Silvertooth.
Michael Dagger Margosian for Mr. Silvertooth.
All right, and so where do we stand with Mr. Silvertooth's case today?
Your Honor, I think we have a trial date in about 2 weeks. We have not got our witness list in yet, but we'll get it in tomorrow. Is all right, is what I think. We just about got it prepared. And we're set to meet with the prosecutor at 11 to go over exhibits or something, or over the exhibits that they plan on using. The only exhibits we have, we've already sent the prosecutor, which are some photos and things of that sort. Actually, we have some other photos, and I think we'll take those over with us when we go today so they can look at them.
And Judge, the only housekeeping matter is we did send, we sent proposed jury instructions, voir dire, and a verdict form to the public defender's office with a stipulation on the jury instructions, I believe, and we have not heard back whether those are okay or there's some sort of issue with those. So I would ask them to let us know that today so we can file a copy of those.
Judge, I'll tell you right now that I don't want to stipulate to any proposed jury instructions. Jury instructions are going to depend on what testimony comes in, what testimony doesn't come in, and to sit here and try to guess. I mean, we want the standard jury instructions. Other than that, we'll have to wait and see what the evidence shows.
Judge, we understand that, of course, but I don't know if we can come to some sort of agreement on the elements of the offense, but we will file what we have with the court today, and we would ask the public defender's office to file anything additional they want prior to trial per the scheduling order.
Judge, just for the record, the only jury instructions we're asking for are the standard jury instructions, unless something comes up at trial that requires a different type of jury instruction.
All right, so the scheduling order covers the process for dealing with this issue, and the deadline for submission of those, I think, has probably already passed. So the parties shall both immediately file their proposed jury instructions, and if there are disagreements between the two sets of instructions, the court will resolve those.
All right.
But I have to start to be able to prepare for the trial, and I can't do that if I don't have the information that is required by the scheduling order.
And Judge, we apologize to the court. We were trying to follow the process, which requires a stipulated set of instructions. So we sent them to the public defender's office some time ago, but we will file what we have with the court today since we can't reach agreement, and then the court can rule on if there is any disagreement later, I guess.
Same would go for any proposed voir dire questions that you have.
Right, we'll file those this morning. We've had them prepared for quite some time.
Is there anything else we need to address today?
No, Your Honor.
No, thank you, Your Honor.
Mr. Silvertooth, you can let the court or the officer with you know that you are done with court for today.
Thank you, Your Honor. That's all I have for you this morning.
All right, thank you. Okay, looks like we got the amended information for Mr. Cook now. Oh. Oh, actually, so we only have one of the two amended informations for Mr. Cook right now.
I just emailed the other one.
Okay. All right, let's see, Ms. Underwood, Mr. Lindeman is here. Are you going to need to speak to him?
I believe so, Your Honor.
So, Mr. Lindeman, if you'll step outside, there's an iPad right outside the door. I will put you in a breakout session with Ms. Underwood. Yes, sir.
What you're gonna hear. Go into the clerk's office, tell me you want to pay
All
$20.
right, Mr. Lindeman, are you there?
Okay. Oh, yes, sir.
Okay, just 1 second here. So, okay, we've got everything on we need for Mr. Cook.
Yes.
Okay, Mr. Cook, we've got all the paperwork we need now, so we can go back on the record. These are files 23-21262-FC and 24-21678-FC. We had previously been on the record in this case, and we do now have the written plea agreement form as well as the two amended informations. And I apologize, Mr. Feifelsky, had you already stated the agreement for the record?
No, not yet, Your Honor.
Okay, do you want to go ahead and do that then?
Yes, Your Honor. And for the record, James Feifelsky appearing on behalf of Christopher Cook on both of those files. The plea agreement is as follows. My client will plead to an added count. I believe it's count 4 in the file 23-21262-FC, and counts 1 through 3 and the habitual supplement will be dismissed. That count will be, CSC 3rd degree. In the other file, file 24-21678-FC, my client will also plead no contest to CSC 3rd degree. Counts 1 and 2 and the habitual supplement will be dismissed as well. There is a sentence agreement between the parties for 10 to 15 years on each file to run concurrent with one another. And I'll just note for the record that I believe a conservative scoring of the guidelines would put the minimum somewhere between 7 years and 11.6 years. So I believe the the minimum of 10 years falls within the applicable guideline range. The purpose of the no contest plea is for potential civil liability in these two matters. I have discussed the terms of this agreement with my client. He understands the terms and does wish to plead no contest as laid out. I will also note for the record, I think it goes without saying, but my client understands that there would also be a requirement to register under the Sex Offender Registry Act as a result of these charges. He is already registered, so I don't think anything will ultimately change, but I would just like to state that for the record as well.
Okay, so I think that what you just stated, Mr. Feifelsky, is different than what I have in the written plea agreement. So I've got in the written plea in file ending 262, he was pleading to added count 4, which is CSC third degree. And in the 678 file, he was pleading to added count 3, which is CSC third degree.
If I did not say that, that is what I intended to say. So yes, I understand those are the exact terms.
Okay, and it maybe I heard it incorrectly too, so I don't know. But as long as we're on the same page now, I think we're okay.
Yes.
Apologize for the confusion. So, Mr. McCready, then is that a complete and accurate statement of the plea agreement?
Yes, it is.
Mr. Cook, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Christopher James Cook, correct?
Yes.
Mr. Cook, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today in file 23-21262-FC to count 4 third-degree criminal sexual conduct?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 15 years in prison?
Yes.
Is it also your intention to plead no contest today in file 24-21678-FC to count 3, another count of third-degree criminal sexual conduct?
Yes.
And do you understand that the maximum possible penalty, again, for that offense is up to 15 years in prison?
Yes.
Are you satisfied with Mr. Feifelsky and the advice that he's giving you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been discussed on the record here this morning. Is that correct, Mr. McCready?
Yes, it is.
Mr. Feifelsky?
That is correct, Your Honor.
Is that also your understanding, Mr. Cook?
Yes, it is.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until your guilt is proven beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial and to have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Cook, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your pleas would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
I do not.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge in file 23-21262-FC that on or about January 1st, 2011 in Lenawee County, state of Michigan, that you did commit the offense of third-degree criminal sexual conduct?
No contest.
And how do you wish to plead to the charge in file 24-21678-FC to the charge that on or about January 1st, 2013 through January 1st, 2015 in Madison Township, Lenawee County, Michigan, you did commit the offense of third-degree criminal sexual conduct?
No contest.
Has anyone made any threats or promises to you to induce you to plead no contest to those charges?
No.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas?
Yes.
Is the prosecutor and defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Cook to plead no contest?
No, Your Honor.
No, Your Honor.
Mr. Cook, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
Just what he stated already.
Okay, anything other than that?
No.
Is it your own choice to plead no contest today, Mr. Cook?
Yes.
All right, and I do have copies of the police report. Perhaps, Mr. McCready, if you would review the relevant information from those, I think it might be better since you're more familiar, and I don't want to accidentally say a name or something like that.
Yes, Your Honor. This is regarding file 2321262, reading from a report authored by Detective Dale Sharp in CR number 220003037-006. This is, I've submitted 3 pages of a report. This is from page 2 of 3, indicating that the incidents reported occurred between 2011 and 2015, that the victim would have been between the ages of 5 and 9 years old during that time. They started when she was in 3rd grade and stopped when she was in 5th grade. The incidents occurred at 6223 West US 223 in Adrian Township. That's the incident that I'm going to be relying on for the factual basis of this CSC 3. It indicates that at that location, which was the daycare that the victim attended, and the suspect, Christopher Cook, resided there with Denise Cook. The reported incidents occurred every time the victim was at daycare. She went there almost every day. The reported incidents are Christopher rubbed and inserted his fingers into the victim's vagina. I think the parties are also going to stipulate that this was done using force and or coercion.
Is that accurate, Mr. Feifelsky?
Yes, Your Honor, that is accurate.
And also that Adrian Township is in Lenawee County.
And you agree with that as well, Mr. Feifelsky?
Yes, Your Honor, I have no objection to the factual basis set forth by Mr. McCready.
Okay, thank you.
In file 24-21678, I'm going to be reading from another report authored by Detective Sharp. This is CR number 230009037-001. This is an 11-page report. I've provided the court pages 6, 7, and 8. And page 6, it indicates that the victim's mother in this matter's name is Kalila, Kalila, Tames, Tames, and that the residence for her and the victim at the time that's in question was 2044 East Carlton Road, which is, I believe, Madison Township in Lenawee County. That the victim was interviewed and advised that it started with Christopher. We're going to stipulate that we're talking about the defendant here, tickling her, and she believes he is her mom's cousin and he used to babysit her when they were little. Going on to page 7, the victim advised she was 4 or 5 years old when this happened, and she didn't know what was right or wrong. She advised all of the other incidents were the same. He would place her under a blanket, he being the defendant, under a blanket and insert his finger in her vagina. The victim advised it would mainly happen in the living room prior to her older sister returning home from school. She advised a majority of the incidents occurred at her old house, but some of the incidents occurred at his mother's house, which was at 6223 West US 223 Highway in Adrian Township, Lenawee County. To conclude, on page 8, the victim advised she remembers he repeatedly fingered her in the same part of the house. She advised this happened for the period of 2 years. The defendant babysat them, and it slowed down or stopped when she started going to kindergarten. She advised it would happen on the couch, and she was covered with a blanket when he would finger her vagina. And again, we're going to stipulate that the penetration was through force or coercion.
We stipulate to that, Your Honor, and no objection to the factual basis set forth.
Thank you.
Has the court complied then with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Feifelsky?
Defense is satisfied, Your Honor.
All right. I'll accept the pleas. Then they have been given understandably, voluntarily, and accurately. Mr. Cook has had full knowledge of his rights and he's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as has been stated on the record this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for October 17th at 8:15 a.m.
And Your Honor, is it acceptable for me to zoom in since I assume Mr. Cook will also be on Zoom for that?
That would be fine. Mr. Cook, you do have a right, since it's a sentencing in a felony case, you have a right to have that hearing conducted in person. If you would prefer to do it by Zoom from the jail, you would need to waive your right to be here in person in order to do that.
I can do it by Zoom.
And Mr. Cook, I'm fine either way. So if you do prefer to come in person, that's fine with me.
Just do it by video is fine.
Okay.
I'm sorry, I just, my court recorder just said that we don't have prints in one of the files. So that will have to be an in-person hearing so that we can have him brought here to have his prints done before the sentencing hearing. So apologize that it's more inconvenient, but we have to do that first.
So we'll have him written
with me.
We'll have him written and in person for the 17th.
Yes, thank you very much, Mr. McCready. All right,
Thank
is
you,
there
Your
anything
Honor.
else we need to address with this file?
Not from us.
Neither from the people.
Okay. Mr. Cook, you can let the officer with you know that you're done with work for today.
Okay, thank you.
Take care, Mr. Cook. I'll see you soon.
Thank you.
Thank you, Your Honor. Have a good day.
Thank you. All right, let's see. Mr. Murphy, are you ready to proceed with Mr. Blevins?
Yes, Your Honor.
So this is file 24-21929-FH People versus Nicholas Montgomery Blevins. We're here today for an arraignment in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
David McCready for the people.
Matthew Murphy, appearing on behalf of Mr. Blevins.
All right, and Mr. Murphy, does Mr. Blevins wish to have the information read?
No, Your Honor, we waive a reading of the information. We acknowledge receipt of said information, the witness list, and the discovery demand from the prosecution in this matter. We're asking the court just to enter and continue a not guilty plea and set the this case for a pretrial at the court's earliest convenience.
All right, so enter a not guilty plea for Mr. Blevins and set a pretrial for how about October 16th at 8:15?
Yes, Your Honor.
All right, anything else we need to address with Mr. Blevins' case today?
Nothing from the defense, Your Honor. Thank you.
All right, Ms. Underwood, are you ready to proceed with Mr. Lindeman?
Thank you, Your Honor. Yes.
All right, Mr. Lindeman, you want to come forward to the podium?
My bad.
Yeah, sir.
Yeah, you're all done, Mr. Blevins. Sorry.
Mr. Murphy, you need to speak to Ms. Caitlin.
If I could, please, Your Honor. Thank you.
Okay, so this is file 24-51904-PH, Leanne Nicole Wade versus Aaron Scott Lindeman Jr. We are here today for a hearing on an alleged violation of personal protection order. We are proceeding today partially in person and partially by video conference. Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Mr. Lindeman this morning, Your Honor. Thank you.
All right, and where do we stand with Mr. Lindeman's case today, Ms.?
We would ask that this matter be set for an evidentiary hearing, Your Honor.
All right. Ms. Clark, can you find us a date for an evidentiary hearing for a PPO violation?
October 3rd at 1:30.
Thank you, Your Honor.
October 3rd at 1:30. Mr. McCree will need a prosecutor for that. Is that the date that works for the people? Do you know?
I'm sure we can make it work. Yes.
Okay, so October 3rd at 1:30, we will send out a scheduling order.
Yes, sir.
Thank you.
So you're all set for today, Mr. Linden.
Thank you. Have a great day.
Okay. Let's see.
Your Honor, do we have Javius Woolley?
We do not. But I can call this case. It's file 23-21329-FH People versus Javius Tremaine Woolley. We're here today for a hearing on an alleged violation of probation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Woolley this morning, Your Honor.
And the record should reflect this matter was set for hearing this morning at 8:15 a.m. It is now 10:13 a.m. Mr. Woolley has not appeared either by logging into the Zoom session or by being present in person here in the courtroom. Ms. Underwood, anything you want to say about Mr. Woolley at this point?
I have no knowledge as to his whereabouts, Your Honor. I know The last time we were here, we were concerned about matters in Hillsdale. So, I don't know what happened with those. I don't believe he's incarcerated. I don't believe.
We do have Mr. Stevenson here from the probation department. Mr. Stevenson, do you have any further information about his Hillsdale case?
I do have some information on him. He skipped a drug test with us last month, and he did not report yesterday. He indicated to me that he was staying at the fairgrounds in Hillsdale, like kind of a tent city is my understanding. But I've had no further contact with him. And last I knew, he was out of jail.
All right, under those circumstances, I'm going to revoke and forfeit his bond. I'm going to issue a bench warrant for his failure to appear here today. I will set bond on that bench warrant in the amount of $25,000 cash or surety.
Of course, if I hear anything, Your Honor, I will get Mr. Woolley to the court at the earliest opportunity.
Okay, thank you.
Thank you.
I believe that concludes my docket with you this morning.
Okay, thank you, Ms. Underwood.
Thank
All right,
you.
are we ready to proceed then with Mr. Felton?
I believe so, Your Honor.
Yes, Your Honor.
Okay, so back on the record, file 23-21654-FHP versus Cody James Felton. The court does now have an amended information and executed plea agreement. Mr. Dagger-Margosin, you want to state the terms of the plea agreement for the record, please?
Your Honor, Mr. Felton will be pleading guilty to an added count of misdemeanor larceny 200 to 1,000. And if the amount of restitution, which is $951.01, if that is paid at the time of sentencing, the court sentence would be fines and costs. The habituals and the original count 1 felony is to be dismissed.
Okay, Mr. McCready, is that a complete and accurate statement of the agreement?
Yes, it is.
I think I've lost Mr. Felton. So at some point during, since I called the case, he was here when I called the case. I'm not sure what's happened, but we'll give him a moment to see if he gets logged back in. Okay, we have Mr. Felton back with us now. Mr. Felton, can you hear me all right?
Yes, Your Honor.
Okay, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Cody James Felton?
Yes, Your Honor.
Mr. Felton, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, larceny of $200 or more, but less than $1,000?
Yes, Your Honor.
Do you understand the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine or 3 times the value of the property stolen, whichever is greater?
Yes, Your Honor.
And are you satisfied with Mr. Dagger-Margosin and the advice he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it here today. Is that correct, Mr. McCready?
Yes, that's correct.
Mr. Dagger-Margosin?
Correct, Your Honor.
Is that also your understanding, Mr. Felton?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial. to have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Felton, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about September 28, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of larceny $200 or more, but less than $1,000?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Felton to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Felton, other than as it's been stated on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
All right, Mr. Dagger-Margosian, would you like to cover the factual basis?
Your Honor, I will. I do want to just make sure of the correct offense date. I know that the amended information has a date of 9/28 of 23. I think that's when the report was generated. I believe that the conduct occurred in January of 2023. So if the people agree with that, I'd ask for that correction.
If you give me a second, I will double check. Yes, the checks in question were written in January of 23.
So with that correction, Your Honor, I'm happy to move forward.
Okay.
Okay, Mr. Felton, in the on or about January 23rd of 2023, did you go to Lowry's Grocery?
Yes, Your Honor.
I'm not the judge, but that's okay.
Oh, I'm sorry.
That's okay. And on that day, well, first of all, that's in the county of Lenawee, state of Michigan. That's in Lenawee?
Yes.
All right. And when you were there, you cashed a check that was illegitimate, correct?
Yes.
And that amount was $951.01.
Yes.
And you knew that you did not have a right to get that money. In other words, that check was fraudulent.
Yes.
Okay. Your Honor, I think I'm satisfied.
Mr. McCready, are the people satisfied with the factual basis?
Yes.
Has the court complied with MCR 6.302 B, C, and D?
Yes.
Yes, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Felton has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as it's been discussed on the record this morning. I will refer this matter to the probation department for a pre-sentence investigation. So that'd be the district court probation office. So Mr. Felton, that would be Mike McCarron on the first floor of the courthouse in district court probation. Yeah, and I'm sorry, Mr. Dagerman, we were setting this out for a period of time to see if he could pay.
Yeah, I'd like to, whatever the court is willing to do as far out as possible, just so we have ample time to get the restitution gathered. So I just ask for longer rather than shorter.
How about December 5th at 8:15?
That's good. Thank you.
It's fine, Your Honor.
So set for December 5th at 8:15. Mr. Felton, you'll need to report to Mr. McCarron in district court probation this coming Tuesday at 8 a.m.
Okay.
So when you do your pre-sentence interview, please be truthful about the offense and about your background. We'll have you back on December 5th for the sentencing hearing.
Thank you, Your Honor.
Your Honor, I'm sorry. Is the sentencing, is that in person or on Zoom?
Mr. Felton, you can choose whether you want to be here in person or by Zoom. In order to do it by Zoom, you would have to waive your right. You actually have a right to person. So if you want to do it by Zoom, you'd have to waive your right to be in person.
Can I do that right now?
If you want to, yes.
Yeah, I want to waive my right.
Okay, so you can just log in by Zoom for the sentencing hearing.
Great, thank you.
Thank you.
Great, so you're all set. You can go ahead and log out. All right, Mr. Sinclair, we have Mr. Milaro now. If you want to come forward to podium. So this is file 24-51771-PP, Sarah Ann Sinclair versus Matthew Richard Sinclair. We are here today for a hearing regarding an alleged personal protection order violation. And we are proceeding today partially in person and partially by video conference. First, let me ask Mr. Malero to place your appearance on the record.
Salvatore Malero on behalf of Matthew Sinclair.
I'm not sure what's going on with your audio, Mr. Malero, but I was not able to. Oh, it's getting a little better.
Salvatore Malero on behalf of Matthew Sinclair. How's that one?
That was crystal clear.
Excellent.
And Mr. Sinclair is here in the courtroom. Sir, you are Matthew Richard Sinclair.
Yes, Your Honor.
All right. And Mr. Malero, where do we stand with Mr. Sinclair's case today?
Your Honor, Mr. Sinclair has a related matter in Judge Anzalone's court. If we could adjourn this for that date as well, I'd appreciate it. That date is October 2nd at 8:30.
Okay, so we can adjourn that to October 2nd at 8. We scheduled ours for 8:15, but obviously you'll want to deal with that one first. So go deal with, we obviously don't call all our cases at 8:15, as you're aware, Mr. Sinclair. So, so deal with what's going on in Judge Angelo's court first, and then you have that worked out.
Judge, the matters involve the same parties. Would it be acceptable for the court to accept my oral motion to consolidate the cases with Judge Angelone, or either one? I don't care.
Yeah, I've got no issue with that at all. In fact, yeah, I'm inclined to do that. And let me, do you have any objection if I just have a quick chat with Judge Anselin about that, and then assuming she doesn't have any issue with it, I'd just send this one over there.
Absolutely not, Judge. I'd appreciate it.
Okay. All right, I will do that.
And if she wants to send you the pending case, it matter. You're both very good judges. I'm fine, either one.
All right, anything else we need to address today?
No, Your Honor.
Okay. Thank you, Mr. Sinclair. Thank you for your patience. You're all set. Thank you, Your Honor. Mr. Murphy, are you ready to proceed with Miss Caitley?
Yes, Your Honor.
Right. Just 1 second. This is file 24-21883-FH People versus Taylor Lee Caitley. We are here today for a pretrial hearing in this case. There's also a pending contempt of court for bond violations. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung, appearing for the people today.
Matthew Murphy, appearing on behalf of Ms. Caitley.
All right, and where do we stand with Ms. Caitley's case today, Mr. Murphy?
Your Honor, at this time, I believe that the offer from the prosecution would involve Ms. Caitley pleading to 1 count of possession of methamphetamine, a 10-year. Now, there has been some back and forth with Ms. Caitley with her bond. So at this point, what I was asking is if Mr. Hartung would be okay with us adjourning this for another pretrial. I'm trying to get Ms. Caitley into an inpatient rehab in Dawn Farms. I am hoping that that'll be done within a week. 2 weeks seems like a long time. But there has been discussions, I think, that we're going to try to get her into enhanced treatment court. I know obviously that's down in district court. But in regards to the matter, we think that, in this matter, just adjourning for maybe a few weeks to see the status of getting her into an inpatient, and then readdressing at that point is what I'm asking, if that's acceptable.
Judge, I have some information on that. Judge, when she appeared before you September the 4th, bond was set at $5,000, but she could be released to residential treatment. She has since been evaluated, and she has been approved for Salvation Army Harbor Light. So I do need to call them today to get a date in which she could have her intake. Once I have that, then she could be released.
Okay. Mr. Hartung, anything from the people's perspective?
We are 100% on board with that program. We are desperately opposed to her being released on her own recognizance at this time. She has violated her bond conditions twice while she was out. And in one of those occasions, she violated on 2 separate conditions. We are all in favor of doing everything we can to keep Ms. Caitley alive at this point in time, Your Honor.
All right. And so, Mr. Murphy, you wanted to adjourn a week to see if she can get transferred there? It sounds like it's close to happening.
Yeah, could we, well, maybe do 2 or 3 weeks, something to that effect, see how if she gets transported there, how that's going, and then I'll talk to Mr. Hartung and confirm what the prosecution's thinking in regards to the offer.
Okay. Let's do 2 weeks then. That'd be September 11th at 8:15.
Yes, Your Honor.
Judge, that's 1 week.
That's just a week, yeah.
Oh, I'm sorry. I can't read my own calendar.
I didn't catch it.
2 weeks is going to be the 18th.
Yes, Your Honor.
And Mr. Murphy, would you do that stip in order, please?
Yes, Your Honor, we will.
So Judge, the bond remains at 5,000, but if she posts that, she can be released to residential.
Could the-
I don't need her to post that if she's going to the residential treatment facility.
Okay.
Thank you.
Anything else we need to address for today?
Nothing further from the defense, Your Honor. Thank you.
No, Your Honor, all set. Thank you very much.
All right, thank you. Ms. Kately, you can let the officer with you know that you're done with court for today.
Thank you, Ms. Kately. You have a good day. Your Honor, that's all that I had. I was going to go log on to Judge Angelone's court now, if that's okay with you.
Okay, thank you, Mr. Murphy.
Everyone have a good day. Thank you.
All right, and Mr. Malero, I have emailed the jail for Mr. Paulding.
Okay, Judge, could I have like a real quick breakout with him when he first gets in? Just like 2 minutes, not even that.
Yep, as soon as they put him in the room, I will set up that breakout session.
Great, thank you.
Okay, Mr. Paulding, I'm going to put you in a breakout session with Mr. Malero, if you give me one moment.
Asking Kaylee, $5,000 bond.
Get $5,000 bond, but she can be. Okay.
As soon as I get the plea done.
are on the record now in file 23-21326-FH and 23-21449-FH, People versus Bush Lee Paulding. We are here today for pretrial conference in both of those files. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. McCready?
Dave McCready for the people.
Salvatore Malero on behalf of Bush Paulding.
Okay, and Mr. Malero, where do we stand with Mr. Paulding's cases today?
Your Honor, I believe there has been a resolution. I believe that plea agreement in writing has been sent to the court, and I will inform the court of it on the record if the court permits.
Yes, please do.
So, Your Honor, the plea agreement is as follows. Mr. Paulding will plead no contest in file ending in 326FH to count 1, and in file ending 449FH count 2, with the habitual offense fourth notice in both files. There is a sentence agreement in the 449FH file of 50 months on the minimum, and with a minimum prison term, and on the 326FH file to be 50 months or less, which shall run concurrent as a matter of law. All remaining counts would be dismissed in both files. Restitution shall be determined by the court and paid by the defendant. Further, in paragraph 9, defendant is entering the plea to an offense that includes a habitual offender supplement that increases the penalty. And parties signed this plea agreement on September 3rd, and all remaining paragraphs that are not so marked were acknowledged and understood by all parties. That is our plea agreement, Your Honor.
Okay, Mr. Paulding, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
All right, and you are Bush Lee Paulding, correct?
Yes.
Mr. Paulding, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest in file 23-21326-FH to count 1, carrying a concealed weapon?
Yes, Your Honor.
Okay, and I'm sorry, are both of those with the habitual offender or just the other file?
Judge, as I read the agreement, it's habitual offender fourth notice in both files.
I agree.
And so, Mr. Paulding, you are pleading to that with the habitual offender fourth offense notice. Do you understand that?
Yes, Your Honor.
Okay, and do you understand that with the habitual offender fourth offense notice, the maximum possible penalty for that offense would be up to life in prison?
Yes, Your Honor.
Is it also your intention to plead guilty today to count 2 in file 23-21449-FH, third degree arson?
Yes, Your Honor.
And you are intending to plead to that again with the habitual offender fourth offense notice, is that correct?
Yes, Your Honor.
And you understand again that the maximum possible penalty with the habitual offender fourth offense notice is up to life in prison?
Yes, Your Honor.
Are you satisfied with Mr. Malero and the advice that he has given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Mr. McCready?
That's correct.
Mr. Malero?
That is correct, Your Honor.
Is that also your understanding, Mr. Paulding?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Paulding, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
And do you understand that you are giving those rights up?
Yes, Your Honor.
How do you wish to plead in file 23-21326-FH to the charge that on or about March 25th, 2023, in the city of Adrian, County of Lenawee, that you did commit the offense of carrying a concealed weapon?
No contents.
And how do you wish to plead to the charge in file 23-21449-FH that on or about August 24, 2022, in the city of Adrian, County of Lenawee, that you did commit the offense of third-degree arson?
No contents, Your Honor.
All right, has anyone made any threats or promises to you to induce you to plead no contest to those charges?
No, Your Honor.
Do you understand that if I accept the pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Paulding to plead no contest?
No, Your Honor.
No, Judge.
Mr. Paulding, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead no contest today?
Yes, Your Honor.
Okay, and how are we establishing the factual basis?
Your Honor, I'm going to do it. When the court's ready, I will begin.
Okay, go ahead.
Your Honor, we believe that the state would be able to prove beyond a reasonable doubt if this matter went to trial as to case number ending in 326FH, that on or about March 25th, 2023, in the city of Adrian, County of Lenawee, state of Michigan, that they would be able to prove that Mr. Paulding had on his person a pistol concealed in his pocket, contrary to Michigan Compiled Law 750.227. The pistol happened to be, I think, a small pistol commonly referred to as a Derringer, and that Mr. Paulding knew that he had this pistol on his person, that it was concealed, and he did not have a concealed pistol license to do so. We believe the state would be able to prove all that beyond a reasonable doubt, and that he would have been found guilty. Is the court and the state satisfied?
People are satisfied.
All right, go ahead then, Mr. Malone.
Yes, Judge, in case number ending in 449FH, on or about August 24th, 2022, in the city of Adrian, County of Lenawee, state of Michigan, we believe the state would be able to prove at trial beyond a reasonable doubt that Mr. Paulding did willfully and maliciously cause a building to burn by fire and explosives. A structure, I think it was Associated Charities, by throwing an incendiary device that had been lit on fire, causing it to explode inside the building and cause a fire, causing considerable damage. We believe the state would be able to prove that beyond a reasonable doubt, and therefore Mr. Paulding would have been found guilty, and that he knew that that's what he was doing. Is the state and the court satisfied?
People are satisfied.
All right, the court is also satisfied. Has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Malero?
I believe the court has.
All right, I will accept the pleas. They've been given understandably, voluntarily, and accurately. Mr. Paulding has had full knowledge of his rights and had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as it's been stated on the record today. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for October 17th at 8:15 a.m. Mr. Paulding, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, Your Honor.
All right, bond will be continued as currently set, and we'll see you back on the sentencing date.
Judge, may I have a quick breakout with Mr. Paulding? I mean, I suppose I can do it. I thought I heard you say for him to be truthful about the offenses, and he pled no contest, so I don't.
Yeah, correct. I apologize. So obviously, it's a no contest plea. Did we state the basis for the no contest plea? Is it civil liability?
Civil liability, Judge.
Okay. All right. So yeah, obviously he's that changes what I said earlier about being truthful about the offenses. So yeah, if you want to say something to him on the record, that's fine. Or if you want to break out session, that's fine.
I think I just did. So
okay. All right, Mr. Paulding, then you can tell the officer that is with you that you are done with court for today.
All right, thank you, Your Honor. Thanks, Malaro.
Yep. I'll be over to talk to you.
All right.
Okay.
Thank you,
And
Judge.
I think that was the last thing on my criminal docket. So thank you both for all your time today.
Thank you, Judge. Have a good day.
Use that.